Three, two, one.
Okay guys, welcome once again to an episode of Scott Talks Law. So this is an episode whereby Scott talks law, and in this episode we're going to talk about the terms of the contract of sale of goods. So these parties that enter into a contract of sale of goods must state down the terms that is to govern their contract or their agreement. So where the parties have not included particular terms, the terms can be implied by court of law or statutes or conducts of the parties. So Sale of Good Act Cap 31 implies certain terms and warranties into the contract of the sale of goods. So in this contract of sale of goods, you must create terms that are to govern new parties who are entering into that contract. If you must include the specific terms that are to govern you. You must place the details of the buyer, the details of the seller, fully describe the types of goods, the particular types of goods that you intend to enter. You must specify the actual price. You must place a clause that will specify the actual amount of payment that if need be. So you must fully describe the goods, the type, name and quantity, and labeling. The price should not be silent. How much should the buyer pay? The clause on the applicable law, which law is to be applied instead if the contract is not adhered to, the terms are not adhered to the terms of the contract. The clause dispute resolution mechanisms. What are the dispute resolution mechanisms that two parties intend to use if the contract has been breached? The clause on the goods delivery. How will the goods be delivered from the buyer to the seller? So the terms implied by statutes, section 13 to 17 of the sale of goods. So the freedom to contract, these parties must have that freedom to enter into a contract. The freedom to decide whether a breach of a condition and warranty is the breach of warranty unless circumstances of the contract are such as to show a different intention there is. Innominate terms are minor. Breach is immaterial. So you must indicate clear terms. So section 14, the right to sell. The case of Roland versus Inval, 1923, 2KB 500. The seller has the right to sell the property to the buyer, and he has that ownership title, and he has that authority to sell the property. So the right is shown by the document of title. So if you are a seller and you have this property, you possess that document of title, then according to section 14, the right to sell, you have that right to transfer ownership to the buyer. Section 15 of the sale of goods by description, it talks about sale of goods by description and must correspond to the description. Goods sold by description must correspond to the description. Goods sold by description must correspond to the description. The particular goods that you advertise, the particular goods that you are showing or displaying to the buyer must be the actual goods that you sell to the buyer. Goods displayed must be the actual goods that the buyer will buy. So goods sold by description must correspond to the description. And it was held in the case of Grant versus Australian Knitting Company Mills. Australian Knitting Mills, 1936. Grant versus Australian Knitting Mill, 1936. So the goods must correspond to the description. So the act of the sale of goods defines what the sale by description means, and the court held However minimal the description is, there is a sale by description. So if the seller described this good, but however minimal the description is, the act says that there is the sale by description. The case of Bale versus Taylor, Beale versus Taylor, it was held that there was sale by description where the buyer looked at the goods, examined them before entering into a contract of the sale of goods. So if the buyer had that opportunity to look at the goods, to inspect the goods before entering into the contract, then this buyer the goods had been described. So there was description where the buyer was inspecting the goods before entering into a contract. That's according to the case of Bale versus Taylor. Also held that there was a description where the buyer personally selected the goods that the seller showed him. So when the buyer selects the particular amount of goods, the particular types of goods that the seller had shown him, then there is this description. So in the case of Bridgeham Hedge and Company Pty Limited versus Francis and Company Pty Limited, Bridgeham and Company Pty Limited versus Francis and Company Pty Limited, 1921, VL 1228. When the buyer personally selects the goods himself, there is a sale of goods by description, personal selection, as I said. It has however been held that the description must be influential to the particular sale so that it can impact on the buyer's description to buy. So the description must be influential to the particular sale so that it has an impact to the buyer's decision. So the description must be influential to the particular sale. So it must influence the buyer so that it has that impact on the buyer's decision. So the described goods must possess that impact to influence the buyer's the buyer to buy the particular good that was described. So section 17 of the sale of goods, goods sold and described must correspond must correspond to both sample and description. Goods sold by sample and description must correspond to both sample and description. And the mobile displayed at the shop must be the one to be packed. You can display an iPhone, then you pack a Techno to the buyer. You pack a Techno. If you're displaying an iPhone, you must pack that iPhone for the buyer. You can't pack a different thing for the buyer. So the goods display must correspond to the one that you pack. Section 16 of the sale of goods. Goods must be of merchantable quality. And merchantable means suitable for sale. Goods must be of a merchantable quality. It must be suitable for sale. The buyer must know the purpose for which the goods are required. So the fitness for purpose is referred to the merchantable. Sweetness for purpose. Is this good that you are displaying suitable for purpose of sale? Is it suitable? You as the seller must know more than the buyer. Must know more about the goods that you are displaying or the goods that you are describing. So the seller must have more knowledge on the goods sold than the buyer. So you're the seller who possesses this good. You know more about the goods. So the buyer knows less than you know what you know about the goods you are displaying. So you can read Article 46 of the Contract of the Sale of Goods and Section 5 of the Consumer Protection Act 2012 and compare with this Section 16 of the Sale of Goods and just see. So the United Kingdom have amended their clause from merchantable to satisfactory. So exemptions and exclusionary clauses. So we have these clauses that are inserted by major parties, the superior party or the bigger parties, to a contract to exempt liability, either 100% or to exempt part of the percentage of liability, to exempt percentage of liability or whole liability. So exclusionary clause and exemption clause. Where there is an exemption clause, the major parties totally exempt themselves from that particular from liability, while exclusionary clauses are those clauses where parties that the bigger parties exempt a percentage of liability in that particular contract. So the seller exempt themselves from liability. More powerful parties exempt themselves by accepting a percentage of liability if it's an exemplary clause. And exclusionary clause is where the seller, the bigger powerful parties, completely exclude themselves from liability. And this is it was held in the case of Lestrange versus Graucob Company Limited, Graucob Limited, 1934 2KB. This is the case that we also find it in the law of contract. So this sale of it was about the sale of machine, and Graucob, the agreement contained terms and statutory notes stated. So the machine could not work, and there was exclusionary clause that Lestrange was not liable. Graucob said that he did not know about the clause, and the court held that since the Graucob had signed, he had agreed. So Graucob was claiming that he didn't know about that clause that was stated by Lestrange. So the court held that even though you didn't know, but you signed. Why did you sign? So for signing, the court could not favor Graucob. So signature prima facie means acceptance. Signature prima facie, the court held that means acceptance. So signing, Graucob signing that contract meant that he had agreed to those terms of the contract. So signature prima facie means acceptance, and more powerful parties are allowed to insert exclusionary clauses. The doctrine of fundamental breach, the courts have come up with this doctrine of fundamental breach, that parties should not run away from their main obligation. This according to the doctrine of fundamental breach. Parties should not run away from their main obligation. So I think that is the end of my episode about the terms of the contract of sale of goods. And next time we shall be talking about duties of the buyer and the seller. So that is the end of my episode.